So anyhow, this is from Inner City Press. This guy was I found him because of the Ghislaine Maxwell coverage. He live tweets all kinds of different hearings and trials and whatnot. And when Good Logic was covering Ghislaine Maxwell, so was this guy. He's in there pretty much every single day. So he's got all kinds of highlights from the Avenatti case and a bunch of other ones. So let's see here. In the afternoon, Avenatti confirmed he wants to represent himself, and Judge Furman granted it. He will cross-examine Stormy Daniels then. Inner City Press live tweeted, you read the thread here, after court on... Oh, wait. No, sorry. Let me go... Let me go back, because I want to see where is... Or maybe forward. Sorry. Okay. From the afternoon of January 25th, they're back. Avenatti, I'm making a formal request to represent myself and cross-examine Miss Rainier. Avenatti, there has been a breakdown of communication with my lawyers. I have superior knowledge about what she testified about. I've heard your Honor's rulings on my counsel's performance. I am still technically a member of the bar. I represented myself in California. Avenatti, Judge Selna allowed me to represent myself under my 5th and 6th Amendment rights, and under Ferretta, I request to represent myself. I am ready to cross-examine now. Judge Furman said, do we take this up now? The AUSA said, we prefer at the end of the day. Judge Furman said, let's deal with it now. You have a right to represent yourself, but it cannot be for delay. It must be timely. I'd like you to know that these federal defenders are able. There will be serious consequences if this is mishandled. I mean, basically the judge is telling him like this is there are some serious risks involved with you representing yourself, just like with anyone. The fact that you're an attorney is no there's no reason why you representing yourself would be really that different from anybody else representing themselves, although you have some extra knowledge and experience in this area. But then Judge Furman said, there's no veiled threat here. The choice is yours, but you do not have the right to manipulate these circumstances. You cannot go back and forth. Judge Furman says, this is an important moment in the case. If you decide to represent yourself, I will appoint your existing lawyers as standby counsel to help you. And Judge Furman says you would not be permitted to essentially testify to the jury without taking the witness stand. You would not be permitted to abuse the dignity of the court or of the witnesses like Stormy. Judge Furman says, would you like time? Avenatti says, may I have 15 minutes? Judge Furman said, no, you have 5 minutes or we'll take it up at the end of the day.
I love it.
That's like, I mean, this is a tough judge that is basically like, you know,
good stuff though.
Yeah, no, I mean, that's federal court for you too. Like they tend to run a tight ship.
Time conscious. The state court, they just let it roll. I mean, they give an estimate, you know, and you saw this in the Edgecombe case. The defense said, oh, we'll take 10 minutes. And like an hour later, you know, they're still talking to a witness.
Yeah. Judge Furman says, how do you want to proceed? Avenatti says, I am prepared to proceed and represent myself. I have one question. I am asking that the jury be instructed that Mr. Avenatti has decided to assist in his defense. Judge Furman said, nope, I'm not accepting hybrid. And then he says, Judge Furman says, now I need to ask about your education, alcohol or drugs, hospitalized for mental illness. Avenatti says, I was hospitalized for surgeries. Judge Furman says, alcohol in the last 48 hours. Avenatti, 1 drink last night. Judge Furman, clear mind. Avenatti, yes. Judge Furman, did you graduate from law school? Avenatti, yes. That was the end of my education. Judge Furman says, tell me about the case before Judge Selna. Avenatti says, I invoked my pro se right just before the jury was sworn. The case resulted in a mistrial. Judge Furman, are you familiar with the federal rules of evidence? Avenatti, yes. Judge Furman says, and with the federal rules of criminal procedure, Avenatti says less than evidence, but yes. And then the AUSA says, Mr. Avenatti cross-examined this witness at length in California. Judge Furman says there may be some gamesmanship here, but if I let him represent himself, there will be no going back. And then he says, I find he's competent. I find that he may and will be representing himself. And then the jury entered the courtroom. Judge Furman gave this instruction saying, jurors, Mr. Avenatti will represent himself for the duration of the trial. He will be the one making objections, questioning witnesses, and making a closing statement. Don't speculate why he has made this decision. We will proceed with the direct of Miss Rainier. The AUSA I guess then goes on. So with the direct examination. So I think it's just wild. The fact that someone is like, you know what, I think I can do a better job than my attorneys, and I'm going to be the guy to do it. What do you guys think about this?
I don't know. I actually, now that I think about it, because it's an appointed counsel, it's not somebody that he selected, right? So, he doesn't have the option. He's given somebody. You can't say, when you get a defender, you can't say whether it's federal or state. You can't say, nah, I don't like this one. Give me another one. This one's no good. Give me another one. You're not going out there and shopping. So at a certain point, if you do feel you're better, for example, for me, if I felt like I was better than that attorney, I would 100% represent myself if I felt I could do a better job than they were doing. If I saw that they were not living up to my standards. Here's the problem. Michael Avenatti is delusional. And I don't think any attorney is going to be up to Michael Avenatti's standards. That's my personal opinion.
Kurt, what do you think?
There's all kinds of reasons to not do it. The biggest problem with representing yourself is lack of perspective. It's the same problem just being able to evaluate yourself just generally in terms of who you are as a person. In some ways, other people can know you better than yourself because you're within yourself and you don't have the same objective viewpoint. So people will see things about you that you can't see about yourself. And in some ways, it can be difficult to be introspective. So there's that same problem with being a lawyer for yourself. It's you lack the objective viewpoint is helpful for if no other reason than the jury themselves are coming from an objective viewpoint. So in some ways, one of the principal reasons you don't want to represent yourself is because the lawyer can, to at least some degree, put themselves in the position of a juror because they're not you. Neither is the jury, right? So they can obviously become infatuated with their own side and lose perspective too, but they're still not going to be as bad at that as you are. They're going to be closer to where the jury is than you are. So that separation is helpful. So the main problem with representing yourself is that you lose the objective perspective, and what is going on in your head may very well not be what's going on in literally anyone else's head. And someone who has some detachment is in a better position. But I think in this particular situation, it's a little bit hard to know without reading more, but you're in the middle of trial. The preliminary work is all done with all the motions and limitations and motions in limine and all that stuff. So there's all that kind of stuff that's been done. You're in the questioning phase. And if you have a strategy that your lawyer won't do, which you are not, the client in a criminal case controls a few things. They can control how to plead. They can control whether or not it's a bench trial or a jury trial. They can make that decision. They can choose whether or not to testify on their own behalf. They can choose whether or not to appeal. And that's about it when it comes to what the defendant has the right to do. So the lawyer has the ability to determine what strategy to choose, the tactics to choose. This goes to the extent of the lawyer being able to choose what witnesses to call and what questions. So if I'm representing you in a criminal case and you say, I want you to ask this question, I can be like, no, I don't have to listen to you because that's not one of the decisions you as a client get to make. I am in control of the method by which we are trying to reach the goal of not guilty. But if you have an appointed counsel like this situation, and you feel that there's a strategy that they're not willing to pick for whatever number of reasons, and you feel like it's a better strategy, then you really have no option at the end of the day but to say, well, I guess I'm going to represent myself. I'm going to trade objectivity and distance for a strategy that I feel is better in the end. And so that might have been a much more complicated answer than you were looking for, but that's kind of what goes through my mind.
I like it though. I know. I appreciate that level of nuance.
That's a deeper level than I was going to, but I agree with what you said, Kurt. I absolutely agree with what you said.
Yeah. I mean, my first impression is always going to be that, there's that old adage that the man who represents himself as a fool for a client.
Yeah.
So that's always going to be my immediate bias. But you're absolutely right. I mean, there could be certain things going on behind the scenes that we don't know about, that are, you know, certain conversations about the strategy and where they're going to go and who they're going to call, who they're not going to call, you know, what they're going to do with objections, that he may be looking at the situation and saying, you know what, I'm a litigator. I know, you know, I know enough about this stuff to be able to know when somebody maybe is throwing my case, or maybe is just not as good as what I want for my case.